She would introduce her group. Oh, well, great. Welcome. Yay. I believe that guests, all guests of Senator Fausto, is that correct? Yes, okay. Sure. Okay, everybody claims them. Okay. All right, great. Okay, before we get started, just a reminder, I know you guys got an email that the testimony for Kay Haug, Director of Epidemiology at KDHE, was misidentified on the hearing for House Bill 2629. That should have been neutral. She was listed on our agenda as a proponent. Another announcement, minutes for February 5th, 7th, and 12th are now on the S drive. We're not passing them today, but thank you for the offer. Just a reminder to take a look. Okay, so today we have, I've got 4 bills that I announced, and I think that's all we're going to take a look at, but we're just going to work bills today, and we don't have a hearing scheduled. So the first thing I'd like to do is pull out House Bill 2581. And Jesse, if you could just give us a reminder of what this bill does.
Yes, thank you, Madam Chair. So House Bill 2581 concerns 2 statutes. So the first statute would be amended to no longer require in the petition that the secretary request an order for child support of a parent of a child that may be in need of care. And then the second statute that is amended by this bill would no longer require the court to order child support. And so therefore, taking out that requirement, it would make it an option for the court to order that child support.
Okay, committee, do we have any discussion on this bill? Anyone have an amendment? Okay, Representative Howerton.
Thank you, Madam Chair. So with what we heard the other day, I guess I'm having trouble putting these 2 bills together. Like, we're not requiring child support, but we're still taking Social Security from children. So can someone clarify or comment on that just to help me reconcile those 2?
Do you have a response, Jesse?
Thank you, Madam Chair. Yes, so House Bill 2581 only relates to child support. So this bill does not have any requirement or changes anything in regards to the secretary's power or ability to apply for those federal benefits on behalf of a child.
So were you referring to another bill besides what we're working? What's the number on that? Okay, 2581 is this one. 2552, it's at the federal benefits, yeah, that's Social Security. So that is one of the ones that we have to look at today. Yeah, well, no, that's fine, it's a good question. Representative Neighbor.
Thank you, Madam Chair. I would move that we pass out House Bill 2581, favorable for passage.
Okay, we have a motion. Do we have a second? Okay, second by Representative Pickert. Is there discussion? Representative Howerton.
I I'm just trying, I'm having trouble with everything that's been presented for us, trying to understand the financial, I guess, a fiscal note on all these and how they're going to be reconciled. So,
Could you do a comparison? Can you read what 2552 was about, is about?
Thank you, Madam Chair. So, yes, so 2581 deals only with child support payments. So when a child goes into the care and custody of the secretary, currently the secretary is required to request child support payments, and then, those monies are to the secretary and those rights are assigned to the secretary to use for the care and custody of the child. And then in House Bill 2552, currently, the secretary, through their practice, not anywhere in statute that I'm aware of, has the ability and the power to also apply for federal benefits on behalf of the child, and then use those monies to also pay for the care and custody of the child. So in House Bill 2552, it would require that those funds applied for and obtained on behalf of the child would go into a separate account and not for the secretary's use. So when you're looking at the two bills, money that could go to the secretary, or that is currently required to go to the secretary, would be an option in this first bill, 2581. And the second one, monies that could go to the secretary, would no longer be able to go to the secretary, and they go into that separate account. So that's kind of what those monies are and the routes and the uses of those monies.
Thank you. That's a really good explanation. I put it together really well. So in thinking about the two bills, the purpose of child support versus federal benefits, Social Security. And Representative Owsley is pulling up the fiscal notes for me. You were going to ask that. So which one's this? The cost, that would cost or a reduction? A reduction in their budget of 2 million, 2.1? I can't read your writing. Yes, Representative Owsley.
Let me find a good spot. Thank you, Madam Chair. It says the Social Welfare Fee Fund report submitted in the most recent DCF budget are expected to be approximately 2.1 million in FY25 and 2 million in FY26. DCF estimates that enactment of the bill would result in a 50% reduction in FY25 and a complete phase out in 26. So it would be a $1 million reduction in 25, and then a $2 million reduction in 26.
Okay, that's 2581. Okay, we don't need to do the other one yet. Okay, is there further discussion? Representative Underhill.
Yeah, on this particular bill, I can't say that I'm necessarily in favor of it. There is a cost to the state to take care of these kids. They're paying for the foster cares and that sort of thing. I sympathize with the families that are working to get their children back and correct the issues that they have at home. But this is also incentivizes them to take care of their business, to get their house in order so that their kids can come home. So I can't say that I'm in support of this particular one. The next one, maybe.
Okay, all right. Representative Wagoner.
Thank you, Madam Chairman. I have a question for our reviser, Jesse. So the order for child support, so you literally could have a case where a parent has been paying child support. Let's say it's, like the wife or the mom has a kid. the father is over here paying child support. But then if the mother is whatever considered unfit, whatever, and the kid gets pulled over to the foster care system, then the father who had been paying child support would not have to pay child support anymore? I mean, is that basically what would happen?
Jesse?
That decision would be up to the court. So the court still has the power to order that child support of the father in your hypothetical.
So it doesn't, okay, I thought it totally said they wouldn't do child support if the kid was in custody of the secretary.
So what this bill does is it deletes the requirement that the secretary requests the court to order that father in your hypothetical pay, but the court, on its own volition, may order looking upon all the factors in the case.
Okay, so it doesn't block the court asking for child support, it just doesn't automatically, the presumption is no longer child support, it would just be more the exception than the rule. Is that?
Correct.
Okay, interesting.
Yeah, it would be on a case-by-case basis or so. Representative Howell?
Thank you, Chair. So just to rephrase to make sure I understand this. So basically what we're saying is we're going to give the secretary authority on a case-by-case basis to decide whether or not to seek child support in an individual case or to waive it. Is that an accurate way to describe that?
I was under the understanding that it's the court that makes.
Okay, thank you. That was a key point I missed. Thank you.
Okay, all right. Is there other discussion? Representative Ousley?
Thank you, Madam Chair. And I apologize to the committee. Maybe not quite all here today, but I would like to read this section from Kansas Action for Children proponent testimony given on 2581. It says, removing these child support order requirements during the process of a child coming into the custody of the secretary will create better outcomes for Kansas children and families who become involved in the child welfare system. Families living on low incomes are disproportionately represented in child welfare cases. For these families, being charged while their children are in care is likely to increase economic hardship and instability. Financial strain only makes it harder for parents to create the stable, supportive conditions required for reunification. I'm going to support this, not only the bill, but this paragraph as well. We know that financial incomes add to all sorts of disparity. You know, we think back to the ACEs that we heard, and we know that it's true there. So I think, you know, for the fiscal impact estimation, I think this is a good thing to do for families that are involved in the child welfare system.
Further discussion, Representative Carr?
Thank you, Madam Chair. I think we need to stay focused on what the intent of the bill is. And the intent is to protect the children and give the children the best opportunity in life. And as much as I recognize and respect my colleagues' assertions that there is a fiscal note that's involved, what's not represented in the fiscal note is the amount of monies that it will cost the state to continue to have that child in foster care if that child is unable to return to their home with their families. Unless I'm mistaken, the intent of this committee is to certainly look out for the children more so than our concern with what it may or may not cost the state. So for that reason, I'll be in support of this bill.
Representative Humphreys?
Thank you, Madam Chair. This probably is for Jesse, but a little clarification. This bill is about when a child goes into care, the department, DCF, requesting child support from the family. This is a different child support than in a custody case. It's not like, I don't think it's I could be wrong. That's where I'd love to get clarification. It's not like what Representative Wagner was talking about, that if there's a family that when one parent is paying child support to the other family, It's not saying that doesn't have to happen anymore. That, it's not about that kind of child support. It's a specific request from DCF to the family for them to help support the child when they're in state care. Is that true?
So this would apply at any point to any child support order or ability to order when a child goes into care, and then the court would re-examine, existing orders and possible orders and order those according to, one parent or both, with those monies being assigned and given to the secretary to pay for the care and custody.
So anyone else understand the confusion? Okay.
Yeah, I
Yeah.
get your confusion. Now, I've had a couple of circumstances where a family has called me, and it was child support where the parents were separated, and the father was paying child support, and the child support then was going to the state
Okay.
for the care of the child.
Okay, so that's super helpful. So that is the situation that Representative Wagner was talking about. So, but then is there an additional situation where, let's say there's no child support orders in place, single parent, maybe the father, something has passed away. So single mom, but child gets taken into care. Does DCF ask her to pay DCF child support?
That is a possibility.
Okay, so it's both kinds of child support that we're talking about here. Yeah, okay. Thank you for that. That's helpful, just to get that.
And court ordered. Okay.
thank
Representative
you.
Howerton.
Thank you, Madam Chair. Maybe a question for Jesse as well. Isn't the court already able to lower child support that's ordered? Is that different than what we're talking about here?
So it's up to the court to determine, in the case, any modifications to an existing order or order new child support based on factors that are in this case.
Okay, so if you could just clarify, so I was involved in a case, like $400 a month was given. They the court judge knocked it down to $50. How is that different? They're already doing that, so how does this bill change that ability that they already have right now?
The bill doesn't take or give the court any extra abilities on their current modification powers.
Good. Representative Lewis.
I have, I guess, two questions and/or objections. The first is along the lines of Representative Howerton. I don't really see that this bill changes much. Currently, the agent secretary is obligated to request child support, and the judge shall order it. But I can imagine situations where the judge orders $1, effectively nothing. And that's, I don't do this kind of work, but I'd assume that happens quite often. So in that sense, I don't see where this changes a lot. And then that raises my next question as to why the fiscal note says we're going to lose $1 million or $2 million a year. That suggests that there are going to be quite a few parents that aren't required to pay for the care of their child. And that concerns me because it's a disincentive, or I put it otherwise, it's actually a financial incentive for them to leave their child in foster care. Whereas the current system requiring them to pay is an incentive. They're basically pawning off the expenses of their child on the government when they're in foster care.
Further discussion? Representative Ousley.
I can't get on board with that philosophy of incentivizing the government to financially subsidize your child. As a parent, I've got to reject that. And then I wanted to just bring back that there were no opponents and no neutrals on this. There were 4 proponents. And we had Cornerstones of Care, Kansas Action for Children, and the Children's Alliance of Kansas with DCF. And I think to the fiscal note aspect of it, if it is going to be, a reduction, that money is going to go back into the household to help prepare the household for reunification, as Kansas Action for Children stated in their testimony, and instead of going for fees or child support collection. Kansas has a privatized child support collection system, and we actually had a special committee on it a handful of years ago, and I sat in on that committee one day. I think I was just a substitute for that day. But one of the things that we went over in that committee was how we could better utilize the system that we have in order to have a greater outcome of collection. And I don't think I've seen anything from that, but I know the way it currently is, it's problematic. So sorry, I just had to chime in on that one. Thank you.
Further discussion? Representative Humphries?
Thank you. My only other question is, I'm reading the testimony of DCF, and DCF was the one that requested this bill. And I know there were 4 proponents, but I'm kind of curious, did we ask the question of DCF, and does anyone remember? They know they're going to lose 1.8 up to $2.1 million because of this. So did anyone ask, how are you going to make that up, or are you okay with this? I mean, I know I'm giving them the benefit of the doubt. They're thinking that's in the best interest of children, so that parents can be working to get their kids back home. I think was their impetus for doing this, but I'm just curious, do we ask them, okay, but you're losing this big chunk, so where are you making it up, and how are you okay with that? Because often in appropriations, we're hearing, that they need extra funds for more caseworkers and so on and whatever. So I don't know. Did we ask them that question, or does anybody remember what their answer was?
I don't recall that question. I just, I do recall that the testimony was that they felt like it was best interest of the child, best interest of family preservation, the whole idea of trying to reintegrate.
Thank you, Madam Chair.
So, but we didn't ask them to justify any of the cost. Representative Howerton.
One last comment, and this is a hard one for me because I want to support the kids. I think it's the best interest for the parents to not have to pay this, to be able to focus on bringing the kids home. But on the other hand, we have to balance, where's that money going to come from and whose responsibility is it? There's innocent parents that are parents that just need help. There's ones that are actually abusing that I think need to pay because their actions should have consequences if they are mistreating a child. So I'm just struggling with this. This is a hard one for me. So, but I do believe in the children. Representative Carr, my heart is there. It's a hard one. Thank you.
And I do think that we keep in mind this bill gives them the opportunity to have it on a case-by-case basis. And maybe that's an opportunity to recognize it. Representative Owsley.
Thank you, Madam Chair. And I didn't ask it on the record, but when we were discussing another fiscal note in this committee, I broke it down, and it was something like $17,000 annually per participant. I want to say it was the sole family. And I got to thinking, well, if we're going to look at this just from a financial standpoint, then I know I had heard in the past, 27, 28, maybe up to $30,000 annually to keep a kid in state custody. I asked DCF that was in the gallery that day, and they said it's closer to 32,000 per kid. So if we're looking at $1 million here versus 32,000 over here, I think that's quite a few families that we could help out. And in a case of severe abuse, reunification is not going to be the outcome. That's not going to be the permanent placement plan for that child. And again, there would be nothing that would stop them case by case to collect that child support, from that parent. And I hope that helps. Thank you.
Representative Howell.
Thank you, Chair. Okay, full disclosure, I have a migraine right now, so I'm not operating at my best. But could someone point out to me where it, in the bill, it says it's a case-by-case basis? I'm having trouble locating that. And then just while we're doing that, I think it is important to consider that not everyone that loses their children lacks funds. Not everyone that loses custody or abuses their child or neglects their child is poor. So it particularly, if they can afford it, I have no qualms requiring them to pay for their child in state care. It is different if the parents are low income, and this is an impediment to them being able to get their family reintegrated. I am totally on board with, making sure that we're not requiring something that's burdensome and slowing down the child being, put back with, reintegrated with their family. But, just because someone is wealthy doesn't mean that they're not capable of using their child, for example.
Yes. Jesse, did you want to answer that on where it is in the bill?
Thank you, Madam Chair. Representative Howell, you'll want to look at page 6, paragraph 3. This is where specifically the bill changes shall to may. So about in line 20, may order one or both parents to pay child support. And then it has, a condition. If the court does order child support, the court shall determine for each parent separately whether the parent is already subject to an order to pay support for the child. If the parent is not presently ordered to pay support for any child who is subject to a jurisdiction of the court has jurisdiction over the parent, and the court shall order the parent to pay child support and an amount determined under KSA 382277. So what I did was I've brought up 382277 to give you some of the items that go into that determination for child support. So in determining amount of child support order under the code, the court shall apply the Kansas Child Support Guidelines. The appropriate amount of support under the Kansas Support Guidelines cannot be determined. If the appropriate amount under the Kansas Support Guidelines cannot be determined by any necessary fact, is not proven by evidence or stipulation of the appropriate parent, the court shall apply one or more of the following. So actually, I need to go to, so that leads me to KSA 20-165, which is the Child Support Guidelines. And so in adopting rules, the court considers the factors of the needs of the child, the standards of living and circumstances of the parents, the relative financial means of the parents, the earning ability of the parents, the need and capacity of the child for education, the age of the child, the financial resources and earning ability of the child, the responsibility of the parents for the support of others, and the value of services contributed by both parents.
Is that helpful? Representative Carr.
Thank you, Madam Chair. Representative Owsley touched on the piece that I was going to bring to this conversation. I think sometimes we look at this as as their standardized numbers or standardized figures, and that's not the case. They have listed the fiscal note based on quite possibly the number of children that would be in the system that have child support that's being taken right now. What we don't see on the other side of that, as I mentioned before, depending on the severity level of the child in custody, what the state pays for for foster care varies, and it varies greatly. I know some foster parents that receive, in excess of $150 each day that they have a child. Depending on the parent's ability to pay, I would venture to say that there aren't a lot of parents that would have the financial ability to be able to pay $150 a day in child support. So that number, it is included in our fiscal note, but we won't know what that number will actually be until we have that particular child in custody, because that varies. So it's difficult to say that we're going to lose $1 million or that we're going to lose $2 million, because what might happen is that because we have those children in custody, we might lose $3 million and $4 million, all the while collecting child support. So that piece is just not as cut and dried as it looks. And again, I believe that the reason that this bill gives the court the latitude to make those decisions, I would certainly hope that the court would take those things into consideration that Mrs. Pringle mentioned earlier, that are currently in the statute. And I just wanted to put that additional piece of information out there for those that may not have known.
Okay, Representative Humphreys.
Thank you, Madam Chair. Great discussion. I appreciate this has kind of clarified a little bit of things for me on this one. So Section 1 is just about what the petition has to say. And we're taking out the piece that says the petition shall contain a request. So right now, the petition doesn't have to contain a request, but it can. It still could. You can put things in the petition that are extra. And so I have two thoughts. One of them is I would like to know if there's a way for us to know next year to get a report. I mean, this would be informal, just asking DCF if they can give us a report. Like, how many petitions contained this, even though it didn't have to anymore? Or was there a dollar amount that paid child support or didn't pay child support? So that would be one thing, just to ask DCF if they would be willing to give us a report. The other thing is a little more controversial, and it would be an amendment to this bill that says the petition may contain a request that the parent or parents be ordered to pay child support. And the only reason, I mean, still they don't have to, so it's not that different, but it still brings up the issue when DCF is filing these petitions. It still brings them to the point of they may do this. And so if it was a family that knew, was very able to pay, then they could. I don't know. I'm just, I'd be happy to have other people's comments on that. But it seems like to me one of those two things would make me feel comfortable with this bill.
Okay, are you making the motion for the amendment?
Usually do conceptual amendments, but.
Well, it's a one word.
Well, yeah, rather than striking the whole section 5, my amendment would be to put in the word may instead of shall. Mm-hmm. Mm-hmm. But it's that first sentence that determines if it's going to be in there or not. Okay, I'll make the motion, and then just if people aren't comfortable with it, it's fine.
Can you
I move
point
that
everyone specifically where it's
Yeah,
at?
so if you have the bill, it's on page 1, line 29. And rather than that whole section being taken out, and Jesse would have to say, so everything gets put back in, and then the wording is the petition may contain a request that the parent or parents be ordered to pay child support.
Instead of be ordered.
Yes. Mm-hmm. Yes. So it's not requiring that the petition has it in there, which is the way it is now, which I think we're trying to get away from. so that it doesn't have to have one in there now. But it still brings it up because like on page 6 that Jesse read to us, on line 17, if child support has been requested, so it still is an option that child support has been requested, as we saw on page 6. So I will make the motion that we make that change to the amendment, to the bill. Yes.
Okay, then,
okay.
got a motion to amend by Representative Humphries, second by Representative Owsley. Is there discussion? Representative Owsley.
Thank you. And for the maker of the motion, I appreciate it, and I appreciate what you're trying to do, and I'm not even positive that it changes the intent of the bill. I think I would be more comfortable hearing from the conferees, you know, that were proponents upon this bill, and I guess, you know, I seconded it just for discussion purposes, but I might feel more comfortable if this were a floor amendment and we could have a chance to discuss with the conferees between now and then upon the actions that we all know one word can make a big difference in a bill. And I just want to make sure that we're not losing the original intent of the bill.
Further discussion? Representative Howell.
Thank you, Chair. So, remembering I'm not an attorney, it appears to me that we're just adding the word may again, that just kind of further solidifies what we already have on page 6. And it's just, we're kind of saying it again a different way. So I don't see how it would change the intent of this law or this proposed bill. So I think I would lean towards supporting it, the amendment myself.
Representative Neighbor.
To me, the two words have a little bit of different connotation. You may do it, you may not do it. It's not a demand or more presumptive. When you say shall, you shall clean up your bedroom. That from me to my child says that will be done. So I think may and shall have different meanings, and the weight of shall is much heavier and is more of, we're going to get this done. So, you know, I like doing the floor amendment and checking that it doesn't harm the groups that testify, to give them the ability. And if we've had that discussion, we would know by the time this comes to the floor, and we could certainly then back up that amendment with, after talking and getting insight from the groups that are responsive. So I would not necessarily vote for this right now because it does have a distinct difference. Thank you.
Representative Howerton.
Thank you, Madam Chair. And I would kind of argue the other fact, if making this amendment gets this bill out of the committee, then we can always change it back after discussion with an amendment on the floor as well. I'm more comfortable with the amendment and the bill than I am. I'm still on the fence, but I'm more comfortable with the amendment.
And I think Representative Howell made the point that it overall doesn't change the intent of this bill. It just has more clarification. Any other, Representative Carr?
Thank you, Madam Chair. I would trust Jesse's opinion, at least with respect to the shall and the may.
Jesse?
Yes, so what I will say is there is a difference between language that is not included in a statute and language that is included. So by taking out lines 29 through 33, it can be an interpretation that the secretary may, but it, you know, that would be up to the secretary's interpretation and the court's interpretation on whether or not they may do so. And by including the word may, it is a little clearer that the secretary does have the power to request if that helps.
Thank you.
Does that help? I think he was asking too on the difference between may and shall.
Yeah, what implications one may have over the other or likewise?
But thank you for the response you gave before, because that was clarifying.
Yes, so between may and shall is the directive that this agency, this person, must do this. And if they do not do this under law, there could be some sort of action brought, mandamus, compelling them to do that action underneath the law. May allows the person to do it if they like, and it doesn't create that action that requires or compels the person to do the thing.
Representative Underhill.
Thank you, Madam Chair. I am so sorry, but my opinion on the amendment is if we just change the word to may, then nothing's going to change. This bill becomes up to the will of the director, and this director's policy might be, yep, we may on every single case that comes in, we may request child support. So this bill does nothing if we still leave the power with DCF. It's just at the will of whoever's in charge at that time.
Representative Carr.
Thank you, Madam Chair. And Jesse, what say you of that last statement?
Yes, so when I incorrectly answered your question the first time, it was kind of speaking to that issue. So if you take this language completely out, it can be up to the interpretation of the secretary of the court that they could, still continue to request it. And then it would be up to the court's determination that without that language in the law, they have the power to do that. And then if you do put the word may in the language, it is clear that the secretary would have the power, both to the secretary and the court, that they may request the child support order.
Thank you.
Any other discussion? Okay, seeing none, Representative Humphreys, you can close on your amendment.
Okay, thank you so much. So I just, I don't want to be repetitive. What this bill does is it takes out the directive that the petition must contain a request that the parent or parents be ordered to pay child support. That has to be in there right now. If we pass this bill, it doesn't have to be in there, but it could be in there. So my motivation for just changing shall to may is just kind of a reminder that the petition may contain the request. I don't think my amendment or the original bill, it doesn't, it's kind of what Representative Underhill said. They're really the same thing, but by leaving the language in with just may, to me, it's a kind of a reminder as an attorney that writes petitions, like, okay, this can be in there. If I deem that I would like for it to be in there, it may be in there, but it doesn't have to be if the situation doesn't seem correct. And so I like it, and I do think it goes along well with that language on page 6 that we changed from shall to may. So with that, I would move my amendment, and I hope that you will see the reasonableness of it. Thank you.
Okay, you've heard the motion. All in favor, the motion to amend. All in favor say aye.
Aye.
Opposed, no. The ayes have it. So we're back on the bill. Jesse.
Thank you, Madam Chair. Just for everyone's information, the way this amendment will look in the bill when you look at the new copy, it will have all that language still struck out, but it will have a new paragraph containing that exact same language, but the shall is a may. And that's just due purely to the way the system works.
Thank you. We've only got a couple attorneys here, so that's nice to not confuse us too much. Okay, on the base bill, any other discussion? Representative Ousley.
Thank you, Madam Chair. And I want to go back to the income that in the Kansas Action for Children's testimony, they have linked a article by Center on Budget and Policy Priorities, published October 13, 2022, says states should use new guidance to stop charging parents for foster care, prioritize family reunification. And the first paragraph mentions most children placed in foster care are there due at least in part to their parents' economic hardships, and charging for such care as most states do imposes extra hardship and delays family reunification. So I found this article and I just wanted to bring it to the committee's attention before the vote. So thank you.
Okay, thank you. Any other discussion? Okay, seeing none, Representative Neighbor, you may close.
Thank you, Madam Chair, and after much good discussion back and forth to make any changes that improve the bill, I would move that we pass out House Bill 2581 as amended, favorable for passage.
Okay, you've heard the motion to pass out favorably as amended. All in favor say aye.
Aye.
Opposed, no. Okay, motion pass. And I hope that is the most complicated one we do. But I do, yeah, good thing we got the extra day. I do appreciate all the discussion because I was having a lot of the same issues and just decided to leave it to the will of the committee. So next one we will look at is 2628. And Jesse, could you give us another reminder of that one?
Yes, thank you, Madam Chair. So House Bill 2628 regards to Secretary's records that relate to a child fatality. So under current law, in the event that child abuse or neglect results in a child fatality, the Secretary may give out certain information in response to a KORA request. What this bill does is it adds another event that would allow the Secretary to give out information in response to a KORA request, and that event would be if the child fatality if there are criminal charges that are filed with a court alleging that a person caused the child fatality that the person is seeking information about.
Okay. Open it up for discussion or any amendments. Representative Neighbor.
I do not have an amendment, but for the purpose of working the bill, I would move that we pass House Bill 2628 out favorably.
Okay, we have a motion to pass out favorably, a second by Representative Johnson. Is there discussion? Nice. Representative Neighbor, you may close.
Thank you. She was going to raise her hand, but I broke it. No, I think this is a very deserving bill and one that people will see clearness in it. And so anyway, I move that we move out House Bill 2628 favorably for passage.
Okay, all in favor to pass out favorably, please say aye.
Aye.
Opposed, no. Okay, motion passes. You know, sorry, I was having a little indecision there. So let's move to 2629. And Jesse, could you give us an explainer?
Yes, thank you, Madam Chair. 2629 is the bill that deals with the State Child Death Review Board statutes. So it amends multiple things. So some highlights would be an updating that the coroner doesn't have to sign a certain form that the board no longer uses. A coroner is to include certain information to a legal guardian of a child prior to an autopsy about findings and instructions on how to get the results of such autopsy, and that a child death certificate be sent by the Secretary for Health and Environment to the board. Additionally, that board membership would be increased one more member, and that member be a physician licensed to practice medicine and surgery, specializing in pediatrics. And then a new subsection stating that the board reviews all Kansas residents under the age of 18 that pass, or non-residents under 18 whose death occurred in Kansas. The section would also allow for board members to have allowances and subsistence. And then it adds another disclosure of information the board would be allowed to do. They would allow to disclose records to any person or entity if the information or records being disclosed are statistics or conclusions for the purpose of procuring and maintaining financial grants. And then the last section requires that the board maintain records for at least 15 years after the date a case is closed.
Okay, are there any questions for Jesse on the bill? Okay, is there discussion? Yeah, Representative Johnson.
Thank you, Madam Chair. This is an important bill, and I am very thankful for the work that this board, Child Death Board, does. And I would move that we pass House Bill 2629 out favorably.
Okay, motion by Representative Johnson to pass out favorably, a second by Representative Ousley. So we'll open it up for discussion, and I have an amendment. Would you pass that out, Jesse? So while she's passing that out, if you will recall, during their testimony, there was a section that had been omitted when they went through the bill. And this is simply amending to add the exact language that they requested. So on page 5, line 27, you can see the, you can see the amendment there. Okay. A motion by Representative Concanon, second to amend, second by Representative Ousley. Is there discussion? Representative Ousley.
I just thank the chair for bringing the amendment and making the bill whole as intended. Thank you.
Okay, any other discussion? Okay, we'll vote on the amendment. All in favor say aye. Oh, I need to close on my amendment. I close. Okay, all in favor say aye. Aye. Opposed, no. Okay, the bill is amended. So back on the bill. Representative Humphreys.
Thank you, Madam Chair. I want to just mention the importance of this bill, the Section 1 especially. I had a constituent that for several years we worked with the coroner's child review death board because they had had a daughter that had a heart condition, and they knew that she was like 12, and she passed away at home because of her heart condition. And, you know, they called and everyone came in, and then later, like several months later, the family found out that they had done an autopsy on their daughter, and they did not know about it ahead of time. And it was just really troubling to them, just the whole thing that happened. And so we worked with how to take care of it. I didn't bring this bill. I mean, this has been like 2 or 3 years ago that we were really involved with this, but this really takes care of that situation because it says that the parents have to be notified ahead of time of how this might happen. And if if they had just known ahead of time, it would have really saved them a lot of anguish and everything. And so I just am in favor of the bill, and that piece specifically. I know there's a lot of other pieces to it, but I appreciate them for bringing it, and I'm supportive of the bill.
Further discussion? Okay, I'll call on Representative Johnson to renew your motion.
Thank you, Madam Chair. First comment, I thank representative here for her comment on the autopsies. Nothing was ever more difficult for me as an investigator than to sit down and ask a parent and let them understand that we were going to do an autopsy. And this is something that will help that. So I would renew that we pass this bill out favorably as amended.
Okay. Well, so can you close on your amendment?
I close.
I mean, not on your motion, sorry.
I close on my motion to pass out favorably as amended.
Thank you, Representative Johnson. Okay, you've heard the motion to pass out favorably as amended. All in favor, say aye. Opposed, no. Okay. We're flying now. So next we'll have 2552, which we heard a little bit about a little bit ago. And so I'll ask Jesse to give us a brief overview.
Thank you, Madam Chair. Yes, House Bill 2552 amends KSA 382216. That is the statute that determines how the expenses of the care and custody for a child in need of care are paid. So there would be a new section in this that would direct the secretary to determine whether a child is eligible for benefits, and if the child is eligible, to apply for such benefits, and then if such benefits are paid out, that they be put into a special account for the use of the child, and those uses would be for unmet needs of the child, and those unmet needs are defined as tuition, tutoring and training, transportation for work, education, helps maintain family connections, housing expenses, and items related to a child's hobbies and interests. And if benefits that are applied for are denied, then the secretary shall consult with the child and the legal guardian on whether to appeal such denial of benefits. And this relates to the federal benefits, such as under the Social Security Act or railroad or veterans.
Okay. Is there any discussion, any amendments? Representative Lewis.
Thank you, Madam Chairman. It's a question for perhaps for Representative Humphreys or others that do work in this area. So as I understand the bill as it's proposed to be amended, it's saying that reimbursement to the secretary. I'm reading from line 2 on line 12, page 2. Expenses for the care and custody of a child alleged or judged to be a child in need of care have been paid by the secretary may recover the expenses pursuant to KSA 39709, 39718B, or 39755. I guess this is really a question for the revisor. What are those provisions about?
Jesse.
Yes, while I look up the other two statutes, that 39709 is the state assistance, so cash assistance, child care subsidy, or food assistance. So this bill does not affect the assignment of the rights of those. When it comes to the other ones, I will find those in 1 minute. Uh, 39755 relates to actions by the secretary to establish parentage for child support orders. So monies that come in through the child support. So 39718B relates to the liability of a parent or guardian for assistance. So this statute states a child's parents or guardian shall be liable to repay the Secretary for Children and Families any assistance expended on the child's behalf, regardless of the specific program under which assistance is or has been provided. It does not apply to assistance provided on behalf of any person other than the child, the parent or guardian. Assistance provided during a month in which needs of parents or guardian were included in the assistance. Assistance provided during a month in which the parent or guardian has fully complied with the terms of an order of support for the child. So this looks like to include, yes, the Secretary may have the rights to the monies under that 39709 and 755, and then 718B kind of creates exceptions saying the Secretary is not available.
Thank you, that's helpful. May I? I was going to call you Your Honor. Miss Chairman. Okay. So before we get to the federal benefits question, does anyone here know what happens if the child comes into money from an inheritance or a lottery or any other means of monies? What happens with that in terms of whether it's used by the Secretary to pay expenses or it goes someplace else?
Jesse, can you respond to that? Well, I feel like that did come up in.
I asked the question, but I didn't get a clear answer, so I'm asking it.
Okay. Okay. So we don't have an answer to that at this time.
All right. So then our amendment is specifically referencing these federal benefits that a child might receive: Social Security, railroad retirement payments, veteran administration. And so my question to the group, to the committee, is why are we distinguishing these payments from other payments that the child may be receiving, or the parents, or through the custody, through the child support and so forth?
Anyone wish to respond? Representative Owsley.
I don't necessarily have an answer or maybe even a response, Madam Chair, but in reading through some testimony here, Kansas Appleseed mentions the historic step of passing Representative Gail Finney's Memorial Foster Care Bill of Rights, and go on to argue that one of those rights is to have and maintain their belongings. And I would argue that among a child's belongings are federal benefits when they are granted as well, according to the testimony. And I'm not going to stand in disagreement with that. And I do recall the inheritance conversation coming up during the hearing on the bill, and I don't recall anybody having an example of it. I want to say the conferees were all in the room, and there was nobody that could come up with an actual story that correlated with that hypothetical situation. And I'll probably have more to say in a second, but I'll quit right there. Thank you, Madam Chair.
I think we have a response from Jesse now.
Thank you, Madam Chair. So I will follow up on maybe a more concrete answer. But when I'm thinking about the inheritance right of a child, the first question is whether or not the parental rights have been terminated. So if the child is no longer a part of the family due to the termination of those parental rights, I'm thinking intestate succession would not have that child a part of the family, and they would no longer have the inheritance rights to some rich uncle across the country, because the child's rights would be severed from the family. Now, that's just a very quick analysis on general principles of intestate succession, but that's something I can look into further.
It's just, but of course, there could be testate succession too. The rich uncle puts him or her in the will, right? So it's not just intestate.
Any other discussion? Did you have anything else,
No,
Representative Lewis?
I'm finished here.
Okay.
Thank you.
Anybody else? Representative Howerton.
Thank you, Madam Chair. And so the dilemma that I have with this bill, and maybe someone can clarify for me, is these, like Social Security, in the death of a parent, the other parent, the child is receiving Social Security in the name of that parent, right? And so that living parent, that's part of their income for taking care of the home. And if the goal is to get the child home and we take that from them, then how is that parent, that single parent now, do they have to go out and get a job? Or are we hindering the fact that they can maintain that home for the child to come back to? I think that the examples we heard were when there was no parents. And so I understand that part of it, but when there is a parent who is receiving those benefits for the care of the child that maintains the home and the bedroom and the clothes and the food for that child, and the child wants to go home, and we pull that funding away, then they have to go out and work, or do they lose their home? And so that's my main concern. If somebody could address that, that would be helpful.
According to a situation I've been called about, is that it's taken now, it's current law. So, Representative Humphreys.
So I will see if this answers your question. In the bill on page 2, on page 20, starting on page 26, if a child is in custody, the secretary receives benefits. The court shall appoint a representative payee in accordance with this federal statute. If the court appoints a secretary as the representative payee, the secretary shall not use the benefits to pay or reimburse for the care of the custody of the child. So the court could appoint the parents as the payee, I'm thinking, by reading this, but that's new in the bill, so I don't know what the old statute said about what happens if a child in custody of the secretary receives benefits. It receives federal benefits. What happens to that money now? How are we changing that?
Just
Yeah, I can just go by what the family that called me about it, and she was very frustrated. The father had died, and teenage girl was removed from the home, and all of her benefits were going to the secretary.
Maybe, was it the court that made
I don't
the
know.
secretary be the payee at that point? Or I wonder
I don't know
how
the
that was
details of that.
decided.
Representative Lewis, did you have other information on that? Okay.
was reading from. I'm reading from line 26 starting, subsection 2. If a child in custody of the secretary receives benefits administered by the Social Security Administration, the Railroad Retirement Board, or the Veterans Administration, the court shall appoint a representative payee in accordance with certain provisions of the CFR. Representative Humphreys, do you know, or does the revisor know what those provisions are about?
Yeah, Jesse?
Yes, thank you, Madam Chair. So CFR 404.2021 is the order of preference for the Social Security Administration in selecting a representative payee for those benefits. So subsection C states that for beneficiaries under 18, the Social Security Administration's preference is a natural or adoptive parent who has custody of the beneficiary, to a natural or adoptive parent who does not have custody of the beneficiary but is contributing towards the beneficiary's support and is demonstrating strong concern for the beneficiary's well-being. Third, a natural or adoptive parent who does not have custody and is not contributing to his or her support, but is demonstrating strong concern for the beneficiary's well-being. Next would be a relative or step-parent who has custody. Next would be a relative who does not have custody of the beneficiary, but is contributing towards the beneficiary's support and is demonstrating concern for the beneficiary's well-being. Next would be a relative or close friend who does not have custody of the beneficiary, but is demonstrating custody for the beneficiary's well-being. And last would be an authorized social agency or custodial institution. And so I think the analysis would be that because this is current federal regulation, this would be the current order of preference. The representative payee would be selected by Social Security Administration in the first place.
Okay, so thank you for that. I think I now understand. So the court, pursuant to the CFR you just referenced, would have order of preference and try and find a relative, presumably, that would get these monies. And then what happens? The relative gives and uses it as they will, or they, I mean, according to the bill that we're talking, in that instance, there would be no trust fund set up for the child. Am I to understand that? It's only if the court chooses the secretary, which is one of the last preferred options, that this trust fund gets set up. I'm just asking if that's people's understanding.
Representative Ousley.
Thank you, Madam Chair. And this might shed some light on the situation. According to DCF testimony, as recently as 2021, 49 states followed the same practice of using these benefits to reimburse for the cost of care. So according to DCF testimony, that currently that SSA and SSI is going to the cost of care. It goes on to say, since that time, at least 15 states and cities have changed their laws or practices and started preserving the benefits for the youth. Also in August 2023, the Social Security Administration and the Administration on Children and Families sent a joint letter to states encouraging but not mandating these changes. Thank you, Madam Chair.
Yes, so, yeah, that does remind us of the Dear Colleague letter. And so that it is a suggestion, a suggested change, and potentially could be more of a required change coming down the pike. Representative Howell.
Thank you, Chair. Again, reminding everyone that I'm not an attorney. My mind is a little bit boggled, okay, I think would be a good adjective to use there. So thinking about this Dear Colleague letter, so the Social Security Administration is actively encouraging this change of policy, right? But the entire purpose of a death benefit from Social Security in this case is to provide shelter, clothing, food for a minor child. So if it didn't have the Dear Colleague letter factor in here at all, I feel like to take that money and put it in a separate account instead of using it for the care of the child is kind of a violation of the federal law, the federal intent of the law, of why they received the death benefit in the first place for a minor child. So that's just kind of, it's just something I'm struggling with. On the other hand, I love the idea of setting up an account to help children who are in foster care, who we all know have so many strikes against them. It's almost like we're stealing from the federal government to the state government or whatever. It just feels weird to my brain.
Well, and in the bill, on page 3, starting at line 15, it uses the words in quote, unmet needs. And so you can see some of those needs are tuition, tutoring, training, book, equipment, testing, transportation. I mean, none of those needs are really frivolous things. They are something that a parent, if they were still alive, would be providing for. That's the part that I recognized when reading the bill. Representative Ousley.
Thank you, Madam Chair. And again, reading from that testimony, it says, under the bill, these funds could be used for current unmet needs beyond care and custody and also set aside for a child's future needs. And if you'll recall from testimony, the gentleman that joined us via WebEx had what was a living example of a child that had the state use his benefits to pay for the cost of care. And I seem to recall him saying, if that was the situation, if I was paying for my care, I want a refund. Because I think that's a fair statement. And of all the kids in state custody, you know, we provide for a level of care for every single one of them without taking any benefits from them. So it's my understanding that this bill would just take and kind of equalize that cost of care across the board. And if there was anything not met by that equalization and the child was eligible for federal benefits, then those federal benefits could be used beyond that. And I think we should kick this out. I'm in support of this bill. Thank you.
Okay, Jesse has some information.
So earlier, Representative Lewis asked kind of about the oversight of other payees when it comes to the benefits. So under federal regulations 416.625, a representative payee is required to report certain information to the federal government. They ask that the payee give information showing a continuing relationship with the beneficiary, a continuing responsibility for care, how they use the payments on your behalf. If the representative payee does not give the requested information, they may stop sending the benefit payments and look for another representative payee. And then the following regulations provide for an investigation process as well.
If I might.
Representative Lewis.
Yeah, I'm a little confused. You're talking about payee rather than, who's the payee in that regulation?
Yes, so that talks to that order of preference that is in the other regulation. So anyone that is going to be the payee of the the federal benefits on behalf of the child. So for example, if the secretary were to be the payee, the secretary would have to report information based on this.
So what you understand is that if the child gets money from any source, well, the payee, though, that's what confuses me. So it would be a guardian of the child or the parent of the child has to report that?
So whoever is going to be the payee of the federal benefits would have to report how the use of those monies in the interest of the child were to be used back to the federal government.
So this is just payees that are getting it pursuant to federal benefits.
So this is information that if the secretary were not, or even if the secretary was the payee of the federal benefit, they have to report to the federal government, notwithstanding any current Kansas statute or the proposed bill.
And the payees then that you're talking about are payees, whether it's the secretary or someone else getting these federal benefits?
Correct.
Okay, thank you. Thank you.
Jesse?
Another federal item that I found when we talk about unmet needs on page 3, maintenance costs as defined by 42 USC 675 So when you're talking about what is being covered and what is not being covered, so the regulation requires that maintenance cover the cost of and providing food, clothing, shelter, daily supervision, school supplies, a child's personal incidentals, liability insurance, reasonable travel, travel for the student to remain in, or for the child to remain in school, when the child is enrolled at the time of placement, also possibly for institutional care, and administration and operation of that institutional care. So that would be that base, what the payments, what is that maintenance costs that is at the base of this. So it's stating that in addition to these, items A, B, C, and D would be funded by the federal benefits in this special account for the child.
Representative Howerton.
I may withdraw this. Are we meeting on Monday?
Yes, we have 2 bill hearings on Monday.
Can I move to table this till Monday so we can have some more time to think about it? There seems to be a lot of questions. I will withdraw it.
Are you making up your mind according to the look on my face?
Yes. I don't want to blow it up. I just think there's a lot of questions. I would like to think through. I'd like to listen to this testimony again with all the federal stuff that Jesse's talked about, and just consider it over the weekend and maybe ask you more questions. Try not to bug you too much, but
If that's,
would that be appropriate?
Sure.
if you're making that motion, it requires a second, I'll second it.
Okay. And that's a non-debatable motion, so
And just my heart is, I don't want to kill it. We still have a day to work this, so I that's not my intent. I just want more time to really get the questions answered.
okay. All in favor of, she did say a date certain,
Yes.
Monday. So all in favor of tabling until Monday, please say aye.
Aye.
Opposed, no? The ayes have it. We will take this up again on Monday. Yeah. Do I need to do anything else? Okay, this would be a good time to, if there's any specific information that you would like from either KLRD, from Jesse or from Natalie, now would be a good time to bring that up. Representative Howerton.
I just want to listen to what all you said again and really ponder what you said. I don't know that I need additional. Maybe Representative Howell does. She's looking at me.
Representative Howell.
I just need to listen to what Jesse said again without a migraine, to be honest. And then I think I'll be okay after that. And if I have further questions, I will ask the chair.
Okay. Okay, Representative Pickert.
Thank you, Madam Chair. So accountability of the payee goes to the federal government. Is that's a question I have, because I could just see some relative, being the payee and they're just having a heyday with that money if they're not accountable to somebody.
Correct, yes. The representative payee of a federal benefit is accountable to the federal government in regards to reporting the use of those funds.
So just as a reminder, if we have questions from DCF, we've got DCF in the room that you can they catch you now? Yeah. If you have questions for her, I guess Andrea's back there in the corner too. And some of our other good stakeholders on this issue, or you're welcome to ask me. You've got the other staff in the room. So, yeah, I referred to 2 bills that we're going to have a hearing on Monday. That's the the EQUA bill, the Indian Child Welfare Act. And the other one is a bill that we had a hearing on last year. I might have mentioned this before. It was brought to us from Adam Thomas, Representative Thomas, and it was regarding reentry into the foster care system. It had been, we'd actually heard it before a previous year, and it had been changed somewhat. And so we're still doing a little bit of work on that. And so we'll have a hearing on that Monday. And then we'll finish working this bill, and we'll probably do some emergency final action. So I'm really appreciative of having this day to be able to work these, because it was hard trying to fit it all in. And I just want to say how much I appreciate having Jesse here to answer all of our questions. Yeah. We're adjourned.